So the Privileges or Immunities Clause of the 14th Amendment is little known outside of constitutional law scholarship. Actually, when we were searching for images of the 14th Amendment, we basically could only find the Due Process and Equal Protection Clauses. We had to look for a while for the Privileges or Immunities Clause. And this is largely because the Privileges or Immunities Clause was rendered practically meaningless by the Supreme Court mere years after the adoption of the 14th Amendment. And it's our position that a revival of this clause can influence positive change in the court's current approach to substantive rights. And the time is especially right now for such a change, as Justice Clarence Thomas has openly advocated for the use of a privileges or immunities framework, and other justices on the court have expressed an increased willingness to reconsider prior substantive due process rulings, as they did in Dobbs v. Jackson in 2022. So we're first going to look at the history of the Privileges or Immunities Clause, then compare the court's current substantive due process framework with the general Privileges or Immunities framework, and then evaluate the benefits of such a framework for constitutional interpretation. So we'll start with the history with Nick.
All right, so the 14th Amendment itself was ratified in July of 1868 in the immediate aftermath of the Civil War, and it was part of the broader Reconstruction efforts in the South to grant rights to former slaves. Now, the Section 1 of the 14th Amendment has 3 clauses, and they're known as the Privileges or Immunities Clause, the Due Process Clause, and the Equal Protection Clause. Now, up there quoted in its entirety on that first bullet point is the Privileges or Immunities Clause. And this clause, at the time of the ratification of the amendment, was actually seen as highly, highly important. And many thought it was the central part of the amendment. And it was also intended to be the primary vehicle through which rights would be protected in the future. And there's a large body of evidence in many speeches leading us to this conclusion, but just one such example is a speech by a senator named Jacob Howard from Michigan, who was very involved at the time of the ratification. And he gave this great speech on the floor where he emphasized that the Privileges or Immunities Clause was the crux of the 14th Amendment, and also was emphatic that the Privileges or Immunities Clause guaranteed by constitutional right the entitlement to certain privileges or immunities for the citizens of every state, and that part about every single state will become important later. Now, right now, I also want to briefly touch on the second clause I mentioned, which is the Due Process Clause. Now, that clause today is the main clause which is used to grant unenumerated rights, that is, rights that are not explicitly mentioned in the Constitution. However, this was not the original intent at all. In fact, at the time of the ratifying and all the debates, the Due Process Clause was seen as merely procedural and nothing more. All right, so at this point, you're probably wondering to yourself, what are privileges or immunities, and what does this clause mean? Now, in order to answer that question, we actually have to look at something known as common law. Now, common law refers to Old English law that was derived based mainly on custom and on judicial precedent and judicial opinions, rather than on actual legislative statutes. And the common law definition of privileges or immunities, and I guess I should also say the reason that it's so important to look to common law is that the American Constitution and constitutional law were founded in large part based off of common law. Now, the common law definition of privileges or immunities, as given by 2 of its most influential figures, Judges Blackstone and Cook, is that they included the protections of life, liberty, and property. Now, here I will also mention that, especially with liberty and property, this doesn't mean that anyone could claim whatever they wanted as liberty or property, and it would be counted. No, in fact, Blackstone and Cook were adamant that only those things that were specifically understood in English religion, English law, and English political theory as liberty or property were allowed to be counted as rights. Okay, so here are some specific examples of privileges or immunities. We can actually look to a U.S. Supreme Court case that was decided in 1823 called Corfield v. Coryell. And this is a good case to look to because it was decided well before the ratification of the 14th Amendment. So at the time of the ratification, the ratifiers would have had some of these examples in mind. And the examples that they had in mind were protection of government to life and liberty, the right to pursue and obtain safety, and the right to acquire and possess property of any kind. All right, unfortunately, so now we have all kind of the background and legal definitions, but unfortunately now we have to talk about something that's really bad. So basically, immediately after the 14th Amendment was ratified, in fact only 5 years after, the Privileges or Immunities Clause was completely nullified. And this started actually with some Louisiana butchers getting into some disputes that ultimately became known as the slaughterhouse cases. And what was really the bombshell, shocking development was that the court's opinion in the slaughterhouse cases responded to the butchers' arguments by saying that the Privileges or Immunities Clause only applied to those areas under the jurisdiction of the federal government. So basically only like federal waterways and ports and things like that, but not to state governments. And as a result, the Privileges or Immunities Clause was basically like completely gone. It could no longer be used as the vehicle through which rights would be protected in the future. So now the court, and frankly more importantly the citizenry, were faced with the question, okay, how will our rights be protected? But before this could even be answered, there was another case that was arguably even worse, just 3 years later, known as United States versus Cruikshank. Now in this case, despite the Bill of Rights, the court ruled that the Privileges or Immunities Clause only applied to the states and not to the federal government. And as an example of some of the ramifications of this, actually it allowed groups such as the KKK to continue discriminating against black people, which is particularly ironic because arguably the number one reason behind the 14th Amendment as a whole was to grant rights to black people who were now freed slaves, which is kind of ironic that now they can't based on this ruling in Cruikshank. So as a result of these two really, really bad cases, a reckoning was kind of needed to be had now with how are we going to protect these rights in the future since we can't use the Privileges or Immunities Clause. So for more information about how those rights would be protected in the process of protecting those rights after these two devastating cases, I'm going to turn it over back to Jeff.
Okay, so in the aftermath of the slaughterhouse cases and Cruikshank, the court lacked a textual mechanism for the protection of unenumerated rights. But eventually they still wanted to protect unenumerated rights, and they eventually landed on using the Due Process Clause of the 14th Amendment and its vague protection of liberty. In 1905, in the case of Lochner v. New York, the court ruled that the Due Process Clause protected an unenumerated right of contract. Subsequent cases protected things like parental education rights using similar due process reasoning. And while there was some pushback in cases like West Coast Hotel v. Parrish, by 1965 in Griswold v. Connecticut, the court seemed prepared to begin embracing a framework for protecting unenumerated rights, which was not in fact grounded in the common law tradition or the original understanding of the 14th Amendment. And so when you're just using the word liberty to define rights rather than something more substantive like privileges or immunities, things can get out of hand very quickly. Under its substantive due process framework, the court has protected so-called rights to contraception, abortion, sodomy, and so-called gay marriage. And the problem with a rights framework which is basically not grounded in the common law tradition or the text or the history or anything like that is that the protection of rights is delegated to personal policy preferences of individual judges or balancing acts that are performed between competing assertions of personal rights. And the court has developed a framework for analyzing rights under its substantive due process framework. It's called the Glucksberg test. And the Glucksberg test basically says that a right is fundamental and therefore deserving of protection if it's deeply rooted in the nation's history and tradition or implicit in the concept of ordered liberty. And while this framework has been somewhat effective in limiting the court's protection of falsely identified rights, it doesn't get to the core of the problem of using the Due Process Clause rather than the Privileges or Immunities Clause, which is that the Due Process Clause lacks basis in the text of the Constitution. It lacks basis in the common law traditions, which were understood by the framers and ratifiers of the 14th Amendment at the time of ratification. And so you're probably wondering at this point, is there a better way? And we believe that there is, and we believe that it's through the use of the Privileges or Immunities Clause, a revival. In McDonald v. Chicago, which was a 2010 case which considered the incorporation of certain Second Amendment protections against the states, Justice Clarence Thomas argued that the court had in fact missed opportunities to return to a textually sound privileges or immunities framework, and instead opted to continue its use of the, quote, demonstrably erroneous substantive due process framework. In the McDonald opinion by Justice Thomas, he argued that privileges or immunities, not due process, is in fact the proper textual basis for the protection of substantive rights. And in his opinion, he used a historical analysis under a privileges or immunities framework to conclude that the right to keep and bear arms is a privilege of American citizenship that is protected against the state governments by the Privileges or Immunities Clause. So he was able to use this reasoning to protect a particular right. And we agree with Justice Thomas that the Privileges or Immunities Clause is in fact a far stronger textual basis for the protection of rights than the Due Process Clause. But what does this framework actually look like? Well, we've got a couple aspects of what a privileges or immunities framework would look like. First, it would share similarities with current constructions like the Glucksberg test that I was talking about earlier. Historical analysis is important for evaluating what privileges or immunities actually are. And privileges or immunities, as opposed to simply liberty, has a far stronger record of historical use to refer to specific rights, whereas liberty is far more open-ended. Secondly, and more importantly, privileges or immunities would require justices to distinguish between whether a right is a privilege or whether it is immunity, and actually examine it more substantively rather than in terms of social connotations or those balancing tests between competing rights assertions that I was talking about earlier. But in practice, would this actually make a difference? Would the court's current approach be any different than what we're proposing? I mean, in Glucksberg and Dobbs, the courts correctly rejected asserted rights to abortion and assisted suicide. In the McDonald case, Justice Thomas and the rest of the majority reached the same conclusion, even though they used different frameworks. And even Justice Alito, in his majority opinion in Dobbs, argued that the court should focus its energy on developing self-imposed limitations to substantive due process rather than developing an entirely new framework in order to take the utmost care when it's deciding these cases. But we argued that there is a difference, in fact, a very important difference, and that taking the utmost care first starts with the proper textual basis for protecting substantive rights, which isn't the due process clause, but rather the privileges or immunities clause. So for the benefits of our framework, Alejandro is going to talk about that.
Okay, so I think first, just to mention that it's really easy to talk about all the problems that we're facing right now, but it's a little bit more difficult to actually point out why our solution actually works. So I'm going to give that a try. And first I'm going to talk about substantive due process and the specific problems we have with it. And then I'm going to talk about a textual benefit to switching to privileges or immunities. And then finally I'll talk about a higher law benefit that Justice Thomas talks about. So to begin with, Justice Thomas gives us 3 issues with substantive due process in the Dobbs concurrence that he gives us. And we believe that the privileges or immunities clause would actually help solve for each of these 3 issues, whereas substantive due process doesn't actually provide any helpful benefit without just a self-imposed restriction that Justice Alito would prefer, which would be through history and tradition. So we think that justices are able to act like policymakers with substantive due process, and Justice Thomas agrees. And he actually points out that that an unenumerated rights theory focused on the natural rights theory of the founding fathers is actually the way that we go about doing this, despite the fact that a lot of people think that Justice Thomas is just like this strict textualist. So with the textual benefit, I would say that Justice Kagan says that we're all originalists now in her confirmation hearings. And I think that I can't express enough how important it is what textual basis is used, especially when we're going off of what unenumerated rights are deserving of protection in the Constitution. So I think that the liberty part of the due process clause is just way too expansive, and privileges or immunities both have definitions that are much more restrictive than the term liberty. And Justice Alito actually concedes this in the Dobbs opinion. So I would also say that liberty actually allows for this judicial policy making, where privileges or immunities would make it a lot harder, because you would actually have to justify how, which one of these rights categories the right would fulfill, and then you would have to point out how it fulfills that category. So for immunities, for instance, I would say that immunities, the common law tells us that the immunities are defined by rights that have always existed and rights that are tied to your human dignity. So this means that they can't just apply to one group of people, and it's also understood in the common law that these immunities are actually not absolute. And this is actually opposed to the current process that the court uses, where they basically just find an unenumerated right fundamental, and then they give that right a strict scrutiny test to protect it against state encroachment. But in reality, our privileges or immunities clause revival framework would be able to actually have a more nuanced approach to this. And so that would be because it would kind of start to inform the way that we think about rights and actually pave a path towards reviving the natural rights theory of the Founding Fathers. And so with the higher law benefit, I would say that there seems to be this false choice that constitutional law scholars put us in, whereas we either have to be strict textualists and we have to only protect the rights in the Constitution, or we can use this unenumerated rights path where we just declare rights protected even if they're not in the Constitution, and we just have this risk of judicial policymaking. But privileges or immunities would be a compromise between the two, and it's actually in line with the original intent of the 14th Amendment. And people think that there'd be chaos if we got rid of substantive due process, but in reality, you could revive privileges or immunities, and it could be a more practical way of fixing the problems with substantive due process over time, rather than it being one big fell swoop of just getting rid of all these rights. And so I would also say that the common law background and history of privileges or immunities makes it nearly unavoidable to kind of acknowledge the natural law background behind privileges or immunities, because that's what it's rooted in. And this will also fix the legal distortion issue, because we have legal cohesion when justices appeal to a higher law, rather than considering themselves as just lawmakers. So this would also take a lot of judicial humility, because they'd have to acknowledge that there's something outside of just them who gets to decide what these rights are, and they'd have to justify it with their other decisions, rather than just cite precedent and try to fix things to make it seem nicer. And precedent would actually be rooted in something that actually is a principled sort of originalism, where you'd be able to say like why precedent actually matters. And it would take a lot more effort for judicial policymaking to take place. So I'd like to conclude with just saying that I think that the privileges or immunities framework is what seems to me the only practical way of fixing the issue with substantive due process. And I think that not only that, but it's the most just and most true solution to this issue. And I'd like to end with a quote from Pope St. John Paul II from Fides et Ratio. He says, "Dogmatic statements, while reflecting at times the culture of the period in which they were defined, formulate an unchanging and ultimate truth. This prompts the question of how one can reconcile the absoluteness and the universality of truth with the unavoidable historical and cultural conditioning of the formulas which express that truth. But it is possible to move from the historical and contingent circumstances in which the text developed to the truth which they express, a truth transcending those circumstances." And so, thank you. We'll take any questions.